Hello, welcome to Company and Partnership Law. Today we are looking at Organization of Company Meetings, which is Section 3 of Unit 3. Session Objectives. By the end of this session, you should be able to explain how notice is given for a meeting, explain what constitutes a quorum, and describe an instrument of proxy and how the appointment of proxy may be terminated. You should be also able to explain the 3 ways in which voting can be done by members. And lastly, you state and explain the types of resolutions. The question is, who may convey general meeting? You should know that the organs of the company, which is members at general meeting, the board of directors, the managing directors, are responsible for conveying general meetings. However, that duty must be exercised by a particular group. When they fail, then it goes to another group. So first of all, the board of directors has the sole duty to convey general meeting. If they fail, the members may do so. Now, the registrar in some cases may convey general meeting, and the court can also make an order for general meeting to be held. Notice of meetings. You should know that before a company can organize a meeting, there should be annual general meeting. There should be at least 21 days notice. 21 days notice. This 21 days notice can be increased, but it cannot be shortened. Also, in the case of a special resolution, the notice will be 7 days. So a special resolution under Section 2 of the Body Corporate Act 1963 at 190. This act is no more in operation. The Act 180 is no more in operation. Act 1015, which is the Corporate Insolvency and Restructuring Act 2020 at 1015, has repealed Act 180. So this same provision can be seen in Section 82. So Section 82 of the Corporate Insolvency and Restructuring Act 2020 Act 1015 provides that in the case of special resolution, 7 days notice shall be given, and the days is exclusive on the day on which the notice is served, but inclusive of the day for which notice is given. So you have to note that one as well. So 7 days exclusive of the day on which the notice is served, but inclusive of the day for which notice is given. So you have 7 days and 21 days. One for a special resolution, which is 7 days, and one for the normal meeting. Remember, it could be increased but not shortened. And this is discussed from paragraph 1 of 8 schedule of Act 992. Quorum. What is quorum? Quorum simply means that the number of people that should be present in a meeting before the meeting can take place. In other words, or if you bring it under company law, quorum is the number of members that should be present in a meeting before the company can proceed to hold the meeting. Now, unless otherwise provided in the constitution of a company, quorum is constituted as follows. So the company's constitution can decide or can state the number of members that should be present before a meeting can be held. However, if the constitution of the company does not state any number, then the following elements will be the quorum. If the company has only one member, then one member being present will constitute a quorum, or the member may appoint a proxy to attend the meeting, when that person is in present, quorum has been obtained and the meeting can go on. In any other case, two members present may constitute a quorum, and where proxies are allowed, that proxy being present may also constitute a quorum. In other cases too, where one person who is present holds more than 50%. So if one person who has more than 50% is also present at the meeting, then such person being present at the meeting will also constitute a quorum. This is discussed under paragraph 6 of 8 schedule. Now, you should know that quorum being the minimum number of members or shareholders that must be present before a meeting can be held. In the case of members meeting, you need quorum at the beginning of the meeting, but as the meeting is ongoing, the number of people fall below the quorum, you can still take any decision. However, in the case of directors meeting, you need a quorum throughout the meeting. Whenever a decision is taken and there is no quorum, the decision will be invalid. Now, proxy. The Act uses proxy in two senses. The first one, the Act refers to proxy as the agent of the member, duly appointed by the member to attend and speak or vote on behalf of the person at a meeting. So, in one dimension, the proxy refers to a person who has been appointed to represent a member at a meeting. In another angle, the proxy refers to the instrument appointing the person. So, proxy is explained from two dimensions, either the person or the instrument appointing the person in question who has been asked to attend meeting and vote or speak on behalf of the member. The decision taken by the proxy will bind the person or the member who appointed him or her, and mostly the member will direct the proxy exactly what he or she should do when it comes to decision making. Termination of proxy. Now, once you appoint someone as a proxy, you can also terminate that appointment. This can be done by one, death. When death occurs, either the appointer or the appointee, the proxy is terminated. Insanity of the appointer. If the appointer is insane, the proxy is deemed to be revoked or come to an end or ineffective. Also, by revocation of the proxy. Revocation here means that you appointed a person and you withdrew the appointment. This is also discussed in paragraph 9 of 8 schedule of Act 992. We want to deal with voting. Voting, when you go for a meeting, normally you vote on decisions. And under company law, you have three major ways of voting. I have that by show of hand, or by poll, or by postal ballot. Now, by default, normally at company's meeting, voting is done by show of hand. However, if you're a shareholder with at least 5% of the voting rights or more of the shares, and you think that the decision that they are taking, if they vote by show of hand, it will go against you, then before the chairman pronounces the result, you ask for voting by poll. You ask for this one. When you ask for this one, the chairman will direct that the voting should be done by poll. In that regard, it will be 1 vote, 1 share. 1 vote, 1 share. So if you're a shareholder with 1,000 votes, you have, if you're a shareholder with 1,000 shares, you have 1,000 votes when it comes to poll, voting by poll. Also, the company, or instead of going for poll, the company may decide to vote by postal ballot. With this one, ballot papers will be given to the individual members to decide on the issue. Types of resolution. We have 2 types of resolutions. We have the ordinary resolution and special resolution. Ordinary resolution is simple. In simple terms, it means that simple majority basis. So the decision is taken on simple majority basis. So majority of the people voting in favor or rejecting the decision before the members is the ordinary resolution. So with ordinary resolution, you need majority, you need simple majority. So it will be 50 plus 1, simple majority. But with special resolution, you need 3/4 of the shares, or you need 3/4 of the people who are entitled to vote. So if you are voting on a decision, then at least 3/4 of the people the decision that will be arrived, or the part which will be taken will be based on 3/4 of the result. Now, if you don't get 3/4, it means that the decision will be rejected. So special resolution has to do with taking decision whereby those people entitled to vote, you get at least 3/4 of the people. It means that when it comes to special resolution, you cannot take that decision when you get less than 3/4. So these are the differences between special resolution and ordinary resolution. Ordinary is by simple majority in terms of decision making, and special resolution 3/4 of the voting rights. By way of summary, to conclude, we have learned that there are 2 kinds of meetings. These are the general meeting and class meeting. General meeting may be convened by directors, members, the registrar, or the court. Notice of the meeting and statement shall be circulated to all members of the company. We also observe that quorum, proxy voting, and resolution are essential ingredients of meetings of the company. Thank you, and I expect to see you in the next class. Have a nice day.